Hi there and welcome to In Your Corner. John Scholes, Sivan Tumarkin, and James Fireman back at it. If you haven't caught our show before, it's about injury law, disability law, looking out for the little guy, which we, I guess in this case, the little guy, the insurance company being the big guy. And we're going to tell you all you need to know about navigating those waters of injury law with adjusters and your insurance company. 1-833 In Your Corner is the number anytime. Help at inyourcorner.ca is the email address. Coming up on the show today, the top 3 things you should absolutely not tell your adjuster, and your insurance company goes after your social media and how they can use that against you. That's all coming up a little later on. But first, basically the week that was, you got a story for us, guys.
Okay. I do. And let me start off by saying that there are many lawyers out there who do what we do. But like in every other profession, some people are better at what they do than others, and some professionals you should hire, some of them you should watch out for. So let me tell you a story about this lady who contacted me from Ottawa. And she had contacted me this past weekend, and she said that she was applying for long-term disability, and she had some questions. And she had reached out to another lawyer who does long-term disability, sure, which is absolutely fine. It's great. I mean, we're here on this show to give information to people, to empower them, to tell them that they have these rights that they can enforce against insurance companies. And so she reaches out to this lawyer, and what does he do? He meets with her, which is great, and then he gets her to sign a whole bunch of documentation, a whole bunch of authorizations, a retainer agreement, everything. Keep in mind, she hasn't been denied, she hasn't been cut off disability. She just had some questions about long-term disability, which is what we answer here. Mm-hmm. And what is the reason that she contacted us later that week? It's because she was afraid. She started getting all these letters and emails from this lawyer saying, you know, I'd like to see a copy of your application. I'd like to see this and that. And really, there's nothing inherently wrong in him asking these things, except that clearly she wasn't ready to sign up, or she wasn't ready to retain anyone. She wasn't, exactly. Right. And one of the things that James and I think, do really well, and our team does really well, is we don't pressure individuals to do anything they don't want to do. Listen, you're getting enough pressure from the insurance company, right, to do X or Y. We tell people day in and day out, you know, it's your claim, it's your life, you're in control. Don't let other people dictate what you should or should not do. And so I explained to her that really all she has to do is, if she doesn't want to you know, go on and be represented by this lawyer, that she can just reach out to him and tell him, you know what, it was a mistake. I no longer need representation, you know, at least not at this point. And that's it. And that's all she had to do in writing, and you know, there would be no issue. But again, the message that I want people to get from this is that you are in control. No one should be pressuring you to sign on the dotted line. And if you do feel pressured by a lawyer, and it's not just in long-term disability, it's any type of law, if you feel pressured, then back up. And in fact, either tell that lawyer you're feeling pressured and you don't want to proceed, or simply walk away and go to someone else, a different law firm, a different lawyer that is not going to pressure you.
Absolutely. When it comes time to make decisions, as a lawyer, our job is to give advice. And sometimes it will be very strong advice. But when it comes to any critical decision, when it is the client's decision to make, we will give that advice, and I will invariably, every single time, say, this is what I think you should do, but it's your choice and you have to be comfortable with it. And if you don't want to take my advice, that's up to you, but you need to be comfortable with the decision that you're making. And you know, if you're doing your job as a lawyer, that's what you're going to do. You have to make your client be comfortable with the decision that they need to make.
That can be pretty daunting for a client who's, like you said, is already under stress. It's like walking into a restaurant, you know, they don't even hand you a menu. They just say, what are you going to take? Order right now. Can I just have a look first, right?
Sure.
That could leave a bad taste in her mouth.
Especially with the retainer agreement.
Yeah.
I make a point of, you know, being very low pressure about that, because someone has to be committed to the process and has to be comfortable working with you. And if they're only there because they feel that they were pressured to do so, that relationship is not starting off on the right foot, and it's likely not going to be a healthy relationship down the road. You have to have trust between the client and the lawyer, and that starts from the very first meeting.
Your partner, Lior, of course, does the Employment Hour on radio, and quite often there's a lot of crossover between employment law and disability law. From that show, we get a lot of phone calls directed towards Sivan and James. As we do every week on the show, we get to some of those calls, and I know you guys like to dissect them, so our first call of the day is coming up right now.
I was sick, and I worked for the government. I used up my short-term disability, and my insurance denied my first long-term disability. Even after I had my doctor's notes, my psychiatrist note, and so on, they said it was insufficient information, which whatever question they asked, my doctors fulfilled that. They'd send them all the information. So now they declined me for the second time, and I had a meeting. They said, we're going to get back to me. Well, it's been over a year and a half that I haven't got paid. I said, I'm running out of money. I said, I had to sell some things to make some payments.
So there are two issues I would really like to address out of this phone call. The first is the notion of the appeal process. I think it's really important that we touch on this so that people understand what it really is. Because when you are denied your benefits or you're cut off your benefits, you're going to get a letter from your insurance company telling you that they've made this decision. But in that letter, at the very end, there's going to be a paragraph about appealing the decision. And that's there for a couple of reasons. Number one, it's there to make you think that there's hope there. But number two, it's there because they want to encourage you to take that step. And it may seem to you when you receive this letter that that's what you're supposed to do if you want to challenge their decision. You may not understand that, in fact, not only is that not what you're supposed to do, but there's a much better way. And the reason for that is very simple. When you bring a long-term disability claim, you are essentially at the mercy of an insurance company. They make all the decisions, whether they're allowed to or not. They don't have anybody who's really looking over their shoulder, especially on a day-to-day basis, checking to see whether the decisions they are making comply with the terms of the policy. And so there's a huge power imbalance there. And so when you appeal, what you're essentially doing is you're prolonging the situation where an insurance company has much more power than you do, because the appeal itself is an internal process. They get to decide whether or not they're going to approve your appeal. It is not impartial. It is done by the insurance company. And so you are essentially prolonging a situation where you are at a power deficit. So you don't want to do that. What you want to do is you want to bring a legal claim as soon as possible. And that brings me to the second point. This gentleman here indicated that he was denied a year and a half ago. From the moment you are denied, the clock starts running on a limitation period. It's 2 years. 2 years from the date that you were denied, you have 2 years to bring a claim, a legal claim. If you fail to bring a legal claim within those 2 years, sorry, you're out of luck. Nothing you can do about it. Even if you've appealed 3 or 4 times with the insurance company.
Doesn't reset the clock.
Doesn't do anything.
Yeah.
Doesn't do anything. And so what they're trying to do is keep you in this appeal process and prevent you from starting the legal claim. And that almost happened to this gentleman. It's quite fortunate that he reached out when he did. So a year and a half, he only had 6 months left. If he had gone another 6 months without reaching out, he's out of luck.
Yeah. John, this person said, I'm running out of money. And, that's front and center. These individuals can't work. Money's not coming in. They have bills to pay. Time is of the essence. James says that they're trying to, keep you within that appeals process, that internal process there, locked down. I would say something a bit different. I actually think that they're trying to shake you off claim. They are trying to frustrate you. They are trying to make sure that you walk away. You walk away from money they owe you. That's what we keep saying on this show and on the radio show over and over and over. And, we have people who call us sometimes who are beyond the 2-year limitation, and we assess their claims. And in hindsight, we can tell them, look, if you had reached out to us even a month ago, a week ago, your claim would have been worth in the 5, maybe 6 figures. I mean, it's crazy, maybe even more than that. So, don't wait. You need that money. And in fact, in the vast majority of cases, when you are on LTD and the insurance company is going to cut you off, they tell you ahead of time they're going to cut you off, right? They're not going to tell you we cut you off a month ago. They're going to tell you we're going to cut you off in a month, in 2 months. I've had one gentleman that was told 11 months in advance that he was going to be cut off. And we had resolved his claim within that 11 months. So there was never a period of time where he had no money coming in. That is absolutely critical. We understand that you need the money to survive and to live. The worst thing you can do for yourself and how you increase that power imbalance in favor of the insurance company is giving them what they want. Either running out the limitation period, in which case they keep all the money that they owe you, or you put yourself in a position where you are absolutely desperate because you've now been without money for a year and a half, and the insurance company is thinking to itself, oh, another month and he's going to give up. So don't be in that situation.
That appeal thing at the bottom, though, is a nasty little creature because, I mean, our regular viewers know better by now. They're going, yeah, whatever, but he'll appeal. I'm going to ignore it. But even as someone, myself again, because I've been doing the show so long with you guys, I would know better. But the average, oh, look, I can appeal. Well, there's the golden chocolate bar right there. Like, it's bad.
It's like
bad.
it's being handed down from God.
Right.
This is what you do. You've been denied, so obviously you must appeal. No, no, that is not what you do. That's only what you do if you want to give in to the insurance company. It does you no good.
Top 3 things you should absolutely not tell your adjuster. That is on the way as we go into a short break here. Stick with us. Lots more to go. 1-833 In Your Corner and help at inyourcorner.ca. This is In Your Corner. Stick around. We're coming right back. You were being harassed, and when you said something about it, you're the one who lost your job. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Insurance companies deny long-term disability claims all the time. They give lots of excuses. Don't give up. I've seen it all. They've ignored your doctors, they've ignored you. You're angry and you're frustrated. But there's hope. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Sivan and his team, 1-833 In Your Corner, or go to inyourcorner.ca. You thought you had a secure job. You didn't see it coming. Now what do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca. And welcome back to In Your Corner. Want to reach out anytime, 1-833 In Your Corner or inyourcorner.ca or help at inyourcorner.ca through email. The top 3 things you should absolutely not tell your adjuster. Why is this so important?
Well, it's very important because throughout the life of your claim, your LTD claim, you're going to be speaking with your adjuster, you're going to be communicating with your adjuster. And you know, your adjuster is going to take everything down. Yeah. They're keeping a file on you. You may not think so. You may think it's your best friend. You may think they're asking you about your vacation, innocuously. Your buddy, absolutely. How you doing? You know, this and that. The reality is that they are keeping track. They are recording everything you say. And they are doing that because they are building essentially a case. I'm not going to say a case against you, but they are building a record that down the road, if they have to terminate your benefits, or they think they have to, or their boss says, you know what, we need to cut off X amount of people this month. I don't know if that happens, but if they do that, I'll tell you, they go back to their file and they figure, okay, look, I'm gonna look at conversations we had in the last few months. The person's telling me that they feel amazing, and I'm gonna use that to cut off the person. So what you tell your adjuster and what you don't tell your adjuster are both going to play into the strength of your claim if we have to get involved to fight for your benefits.
Set the table nicely. We'll get to number 1, that you're generally feeling better than you really are. You're being a hero.
Yeah, you got to be really careful about that. A lot of people have it in them that they think if they complain too much, they're not going to be liked. And so when you're talking with your friends and family, you tend to limit how much you're complaining just because most people don't want to hear that. Most people don't want to know everything that's bothering you. When you're talking to your adjuster, as we were just saying, everything is being recorded. I'm not for a moment suggesting that you should exaggerate anything, but just tell it like it is. If something is bothering you, tell them. If something is worse than it was 2 weeks ago, tell them. If it's better, you can acknowledge that too, but make sure that you put that in context. If you've had a good day, okay, fine, you've had a good day, but that doesn't mean that every day for the last 3 weeks has been a good day. The other thing that you really want to be careful of is just your initial greeting. Because you may think that you're friends with the adjuster. You're not. You can be friendly, but that doesn't mean you're friends. The adjuster has a job to do, and that job is to find a way to cut you off sooner or later. That's what they're trying to do. And so when they greet you on the phone and they say, "Hi, John, how you doing?"
Great.
No.
Very simple comment to make, right? Very innocuous, right? I'm great.
Right, but that's what's going to be recorded. John is doing great.
Ugh, that's bad.
That's the first thing that's going to be on that message.
Right.
And I see this time and time again when I get the file from the insurance company and I go through every phone call, every log note that the adjuster has made. Very first line, John's doing great. No. If you're not doing great, don't say that. You have to be very careful when you're talking with your adjuster. You don't have to be rude, but you have to be careful. Choose your words wisely.
3 little words. I'm doing great. You don't mean you're doing great, but it's just vernacular.
Yep.
That's scary. It really is. Top 3 things you should absolutely not tell your adjuster. Number 2 is that you're not complying with treatments because you've simply given up.
So you have to understand that under the terms of your policy, every policy, as well as just the law generally, you have a duty to mitigate. Yep. What does that mean? In layman's terms, that means that you have a responsibility to get treatments. You have a responsibility to try and get off disability, to try and get back to work, to try and follow your doctor's recommendations, to try and get better. And, you know, it's okay if you can't take certain medications because they're making you ill. It's okay if, you know, you can't do certain physio exercises, as long as you have a channel of communication that's open with your doctors and they can provide alternatives, right? And you can follow something else. The point is this: if you tell the adjuster that you're not doing something, you're not following certain recommendations or taking certain drugs, give context. That's what James said. Context is key. And I would even say, and James has said that before as well, make sure that you follow up with an email explaining exactly what it is. What is the reason why you're not doing X, but you're going to do Y? Because the last thing you want the adjuster to put down is that you've given up, that you're not mitigating. As soon as the insurance company has something to latch onto, something you've said, something your doctors have said, this person is not complying with treatments, period, as opposed to this person is not taking this medication because this medication is making them ill, as soon as there is no reason attached, the insurance company is going to use that to cut you off. I'm almost guaranteeing that. I say almost because sometimes they'll find a different reason in addition to this one, right? But the point is this: they're looking for a reason to cut you off. So, you know, other than the fact that, just generally speaking, legalities aside, you want to try and get better. I mean, as a normal person, you want to try and get back on the horse. You want to make sure that you don't give the insurance company ammunition. You don't want to tell the insurance company you've given up, it's hopeless, there's nothing that you can do anymore, there's no point following what your doctors are saying, what your psychologist is saying. As soon as you say that, they will record that. They will then throw that back in your face along with a letter saying we're cutting you off. Do not do that.
So don't wait a month if a medication's making you sick, and then finally the adjuster says, well, you were supposed to be taking that for the last month. Yeah, it was making me sick. I stopped.
No, make sure that you tell the adjuster right away. And I would actually add to that, go to your doctor and make sure that your doctor has it documented in their notes and that your doctor agrees that, yeah, you shouldn't keep taking that medication.
Right. Top 3 things you should absolutely not tell your adjuster. Number 3 right now, guys, that you think you'll be ready to go back to work when your doctor now advises you that you should not be doing that.
Yeah, this is a real big issue. When you are in a disability claim, the only advice you're listening to when it comes to a medical decision is your doctor's. And whether or not you are fit to return to work is a medical decision. That's not a legal decision. So if your lawyer tells you you should go back to work, but your doctor says no, you don't go back to work. If the insurance company is telling you that you should go back to work, but your doctor says no, you shouldn't go back to work. Listen to what your doctor is saying. That's just from a medical perspective. Mm-hmm. From a legal perspective, you have to listen, because if you say, oh, I think I can go back to work, and your doctor doesn't agree with you, that's what your insurance company is going to hear. They're not going to care that your doctor says otherwise. They're just going to hear that you think you can go back to work. And then if you try and aren't able to, which would make sense because your doctor has told you medically you shouldn't go back to work. So if you try to go back to work and you fail, the insurance company isn't going to care. They're not going to care that your doctor says that you can't go back to work. All they're going to hear, all they're going to remember is that you've told them that you're ready, and that's what they're going to rely on. And if you say, no, I need to go back on disability, they're going to say sorry.
It's an interesting point, though, because your last point was you have a duty to try to mitigate. So if viewers are going, okay, wait a minute, you're saying I shouldn't go back to work, or I should go back to work, I should be trying to, right?
No, absolutely you should be going back to work if you are capable of doing it. But if your doctor is telling you that medically you are not able to return to work, you should not return to work. Simple as that. So it's not about not mitigating, it's not about not trying. If you feel like you are ready to go back to work, the first thing you do is you have the conversation with your doctor. Exactly. Get your doctor's view on it. And if your doctor's on board, then by all means, you do better if you're earning a full paycheck. There's no doubt about that. Right. But if your doctor isn't on board with that, then that's it, full stop.
Now, John, I just want to mention something. 100% agree with everything James said. I think sometimes people feel like they want to please the adjuster. The adjuster is goading them into, well, maybe you should try to go back to work, almost like guilting them into, feeling like they're being lazy, when in fact their doctors are saying, no, you're not ready. I've seen that happen before, and I've seen situations where the insurance company's doctors are the ones who are telling this individual, yeah, forget about what your doctors are saying. I'm telling you that you should be able to go back to work. And again, people oftentimes want to please these insurance companies because they're afraid of getting cut off.
Sure.
You're going to get yourself cut off so fast, before you can even see it coming, if in fact you tell the insurance company, no, I actually think I can go back to work, when the reality is you cannot. So be careful of falling into that trap of wanting to please the adjuster, wanting to please the insurance company, giving them what they want, when what they really want is to get you off claim. They don't care if you're ready to go back to work. So listen to whatever your doctors are saying. Have that channel of communication open. They have your best interests at heart, not the insurance company.
I've actually seen insurance companies do this much more subtly. And they'll do it by suggesting, well, maybe you're not ready to go back to work yet, but maybe you're ready for a work hardening program, right, or a gradual return to work program, or something that sounds kind of similar to that. It's the same sort of thing. You have to go to your doctor and get your doctor's view on whether or not you are medically able to participate in that before you say to your insurance company that is something that you're interested in. Because if you say that you're interested in a job hardening program, or some transferable skills analysis that will reveal some other jobs you might be able to go to, but your doctor says you can't return to any occupation, the insurance company is just going to hear that you want to go back to work. That's all they're going to hear.
Moral of the story, listen to your doctor, basically, right? Help@inyourcorner.ca is the email address. We like to get to a few of these during the show each week. AJ writes in, says, last year my son was injured in an assault. His therapist and psychologist say he has PTSD and he can't go back to work. He was denied LTD because the insurance company feels that he can go back to work. Here we go. He's all but given up, and I'm afraid that he'll become suicidal, to be honest.
Well, it's obviously a very serious situation. And I'll tell you, John, I'd say more than 50% of the disability claims that I handle have an element or are exclusively mental health issues. PTSD in particular is a very serious claim. Even though it lies on a spectrum, unless you reach a certain threshold, the doctor isn't going to tell you that you have PTSD. They'll tell you you have symptoms of it. So if you've actually passed that threshold, right, it is by definition a very serious condition, and it's not very difficult to understand why that might prevent you from being able to work in any environment. So, in this particular case, we're talking about an individual who has the support of a treating therapist and psychologist. Right off the bat, if I understand that a person has gotten the support of the medical community and their therapist or their psychologist is telling them that they're not prepared to, that they're not ready to go back to work, I know that we're talking about a solid claim here right off the bat. Another huge issue when we're dealing with people that have mental health claims is the issue of the anxiety that comes with dealing with an insurance company. And as you can gather, if you're listening to this show, if you're watching the show, or if you have your own disability matter, you know that dealing with an insurance company is not an enjoyable proposition. It's not something that people like even at the best of times. But when you're dealing with even issues that aren't quite as severe as PTSD, mild depression and anxiety, that's going to aggravate it severely if you're having to deal with an adjuster who is second guessing every decision that you're making. Well, here's the good news. Once we start a legal claim, you don't have to worry about the insurance company anymore. That's our job. The moment a client signs a retainer with our firm, they no longer have to communicate with the insurance company directly. We do all of that. The client then gets to focus all of their attention on the rehabilitation, making sure that they are able to go through all the treatments and just focusing on getting better, which is often a huge relief, and it's usually the biggest benefit that clients get right out of the gate.
How far is too far when it comes to seeing the insurance company's doctor? We'll get to that after a short break. 1-833 in your corner and help@inyourcorner.ca. Lots more of the show is coming up. Stick around.
You lost your job. They only gave you 2 weeks of severance per year worked. But where can you find out what you're really owed?
I'm going to severancepaycalculator.com.
Find out how much you're owed right now. severancepaycalculator.com.
You've been denied long-term disability. You think you're powerless, but you have a lot more power than you think. I'll tell you a secret. It's a numbers game for the insurance company. They're betting on you walking away from money that they owe you. Don't make that mistake. We resolve disability claims all the time. We force insurance to pay what they owe. We're in your corner.
Call Sivan and his team, 1-833-IN-YOUR-CORNER, or go to inyourcorner.ca. You lost your job. They said they had a good reason, but you think you've been wrongfully dismissed. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Now, welcome back to In Your Corner, 1-833. In Your Corner is the number to contact. Sivan or James, member of the team. help@inyourcorner.ca is the email address. Before I get to another email from Lee, you wanted to mention something about AJ's last email, yeah?
Yeah, I just want to mention and really tell people out there that oftentimes it's not the individuals watching who are the ones who are disabled, who are struggling. In the previous email that James was talking about and responding to, it was AJ calling on behalf of his son.
Right.
And I just want to make sure people understand that it's not just about you. If you know someone, whether it's a family member or a friend or a colleague that is struggling with long-term disability, struggling with the insurance company, have them contact us or you contact us on their behalf. We speak with people all the time. Ultimately, we'll deal with the individual, but these people who are now struggling with disability, people who are potentially suicidal, people who can't get out of bed, these individuals don't have the strength to pick up the phone or to type an email to us.
Yeah,
so take the initiative.
Especially when you're talking about someone who's suffering from a mental health issue.
Absolutely. Yeah. We see this all the time. In fact, I think the vast majority of people who contact us who have issues, mental health types issues, it's family and friends who are contacting us. So be proactive and actually do that. Because if you don't do that, then they're just going to fall into the abyss and the insurance company is going to win.
Get to another email, guys. Again, help@inyourcorner.ca. This is Lee writes in, says, does a disabled person have to travel for hours? I'm talking 5 or 6 hours just to see a doctor for an assessment that's been arranged by the insurance company.
So this is an interesting question because the insurance company is going to tell you, and in fact, I see people, talk to people who tell me the insurance company cut me off because they say I didn't agree to go to one of their assessments. In fact, I have an individual from British Columbia right now who said exactly that. And she has a lot of mental health issues. She's definitely afraid of getting out of the house. In fact, a lot of the communications I have with her is with her and her husband. Mm-hmm. And the insurance company wants her to go and see an assessor that's about 11 or 12 hours away. Now, here's the thing. She never once said to the insurance company, I am refusing to see the assessor. What she said is, I want to see the assessor, but either have someone who's closer to me or, if you don't mind, my husband would come with me or perhaps pay for my transportation. You know, if you were to look at an LTD policy, it's not going to stipulate all of these details. It's simply going to say that at their request, you have an obligation to do X, Y, and Z, whatever that is, whether it's to participate in a rehab program or see an assessor, whatever it is. But look, they can ask for unreasonable things. They can't tell you that they have an assessor in Zimbabwe and ask you to fly there. They can't do that. But if you tell them you're unable to travel that distance or to do X and Y, you're not saying you're not going to do it.
Just give me an option.
Yeah, give me options, help me out. There's nothing unreasonable for you to say that, but the insurance company will read that, the adjuster will read that as you are refusing, and so therefore, based on that refusal, you are breaching the terms of your policy, therefore we're going to cut you off. Not so fast. Not so fast. And I've had cases where as soon as we start a legal claim on one of those issues, I got a call from the defense lawyer appointed for the insurance company saying, how can we resolve the case?
It's 11 hours. I mean, just so you know, from Toronto to Algeria, which is the north of Africa, is 7 hours. I mean, really? 11 hours?
Yeah, if an insurance company can't find a doctor that is closer than that to you, and they have to have this particular expert, then they should fly them in to see you.
Yeah.
Yeah.
As simple as that. Unless you're living maybe in Nunavut, right. I don't understand how it would be reasonable to require you to travel that far to get an assessment.
And most insurance companies would comply and say, okay, we get it, you're willing, but we'll get someone closer?
No, most of them are going to cut you off, and then we're going to argue.
Oh, nice.
They're going to cut you off. So what you can do to protect yourself is, you document in writing, in an email, you say, I'm willing to do this,
right,
but I'd like some help. I'd like some help with transportation. I'd like some help, perhaps bring the assessor here. Don't say that you're refusing. That's the one thing, and confirm that by email.
Online anytime you want to find out old shows where you can see them, the podcasts and radio shows as well, inyourcorner.ca. The email address we've been reading from is help@inyourcorner.ca. Bit of a theme going here. And 1-833-IN-YOUR-CORNER is the phone number to reach out anytime. Thank you for joining us. Guys, we'll join you again next week. This has been In Your Corner. Till next time, have a wonderful week.